Mr. Zanini.
Good morning. May it please the Court. John Zanini for the Commonwealth. Since the matter is impounded, I will not be referring to any of the facts, names, places, times at all. I'll stick with the strict, narrow legal issue, which is whether there was an error of law in allowing the invocation of the spousal privilege before the grand jury. The Commonwealth contends that the grand jury is a body or a proceeding at which the legislature did not make the spousal privilege applicable.
Mr. Zanini, let me ask you, what is your position about whether the spousal privilege would apply at probable cause hearings?
It's an excellent question. I think that the probable cause hearing, as we understand it today, and I can't say 100% because I didn't have time to go back and read all of the earlier probable cause cases prior to the current 21835, but I don't know whether defendants had any right to be present at a probable cause hearing, and by this I mean the pre-issuance of a criminal complaint probable cause hearing, or to present witnesses at those hearings as they now do. So prior to the issuance of the criminal complaint, when there is no criminal charge pending, I'd say it's an open issue whether that's a criminal proceeding. I believe there may be some U.S. Supreme Court case law that characterizes those proceedings as criminal proceedings for purposes of public access. So there is some guidance out there. I could find it for you. There's a separate probable cause hearing that occurs after the issuance of a criminal complaint, which the defendant, or rather the witness, sorry, mentions in her briefing. And that probable cause hearing is a determination of whether there is sufficient competent evidence to go to trial. And I think because the determination the court is making is whether there is competent evidence which would allow a conviction beyond a reasonable doubt after the charge has been issued at that probable cause hearing, I think the privilege would apply there because the court is assessing competent evidence to go to trial.
What about at a deposition? If a deposition is allowed in a criminal case of the spouse, and she comes in and says, I'm claiming the privilege, apply, not apply?
Well, depositions can be used at trial. It would seem to me that's, in fact, an easier question.
Can a deposition be used at a trial?
Well, yeah, the answer is yes.
Yeah.
That's evidence. That is to say, it may be that the witness is living abroad. I mean, you don't.
You're preserving the testimony and that sort of stuff.
So clearly, she can.
Well, there's a rule that allows a deposition to preserve testimony in a criminal case. Whether or not that rule actually passes constitutional muster after Crawford v. Washington,
that's a different issue. But at least,
we don't know yet.
As I understood your original, as I understood your distinction that you were drawing for Justice Cowan, it's whether or not there's competent evidence to obtain a conviction, and at least at the present time there might be some deposition testimony that might be used for some purpose that would be, quote, competent evidence.
So it applies there.
I don't think that
my sister just asked you about a motion to suppress.
Evidentiary motion to suppress.
I would say this. It doesn't apply to depositions in the traditional sense of civil depositions in trial.
No, I wasn't asking that.
Okay.
So forget depositions.
A criminal deposition under the criminal rule 35.
More or less agree it applies.
I would say the legislature didn't contemplate that rule, didn't contemplate depositions in criminal cases, and didn't make their privilege applicable to that deposition. On the other hand, you can interpret and say, well, clearly that's a criminal proceeding. It's part and parcel of the trial preparation, so you could reasonably interpret the privilege to apply.
Even if it's pre-grand jury, even if the deposition is pre-grand jury, which it may well be?
Well, the deposition could only be pre-grand. I'd have to open the rule book and look at Rule 35 and see if it applies in a district court proceeding. If it applies in a district court proceeding, then I would say, sure, pre-grand jury, it would still be, there's a pending criminal charge. The purpose of the deposition is to have competent admissible evidence at trial. Under that narrow rule, maybe that's a criminal proceeding to which it applies.
So you would say that it applies, so you'd say it applies pre-grand jury to a deposition, doesn't apply at the grand jury.
But I would only say that if you're going to go and stretch that statute as far as you can stretch it, and you're probably snapping it, because the legislature wasn't contemplating a rule that this court came along and enacted many years after the statute.
That happens all of the time, Mr. Zanini, and then what we try to do, when we say to the legislature, you may want to address this, but in the meanwhile, you have to decide the case, and what you try to do...
And that's not the case here,
instead
fortunately for all of us.
Instead of dealing with the esoterics of depositions in criminal cases, which is a very, very esoteric subject, evidentiary motion to suppress.
Mm-hmm. The answer to that, first let's start out with something that's absolutely crystal clear. The privilege is not so sacrosanct that it applies in civil proceedings. Okay? In the 1870, the legislature said spouses are now competent, defendants can testify on their own behalf if they choose in a criminal case, parties are now competent witnesses, but we're granting parties and spouses a privilege. It's a limited privilege. It does not apply at all to civil proceedings. Now, to answer that question directly, suppression hearings, the way we conduct them today, didn't happen the way they do today back in 1870 when the statute was adopted. The suppression hearing, at best, you would excuse the jury, conduct a voir dire of a witness, and make a decision. Maybe you had an involuntary confession that's excluded. So the suppression hearing would really be just part of that trial. It would be an evidentiary ruling. People would object, take exceptions, a record would get created. So I would suggest that the suppression hearing, it does apply in historical context because of what the suppression hearing is.
Now, we just do the suppression hearing earlier so it doesn't slow down the trial.
Correct.
Okay.
It's pure convenience.
So if we overrule Judge Subpoena, you're permitted to do this, then she testifies, because I guess the grand jury's still in session, or perhaps it'd be moot, maybe not moot. But anyway, she testifies under oath, and then she gets to the trial, and she claims her privilege. And then what? You introduce the grand jury testimony?
Probably not. Well, back up a step. It's not moot because the grand jury is returning on Friday, May 5th.
Well, that's fine. We still have to answer it because it may come up again. But
if she claims the privilege at trial, she clearly has a trial privilege.
Correct.
The purpose for introducing that at grand jury is not to necessarily create testimony to then use at trial. Number one, she may have exculpatory evidence that the grand jury ought to hear. Number two, she may have evidence about non-spouses who are accessories after the fact in a given case, who are conspirators, who are joint venturers, and her testimony against those people is competent and admissible. Whether there's, they would have to be separately tried, there would have to be a severance. That may not be the precise facts we have here, but clearly the grand jury is entitled to hear that exculpatory evidence, is entitled to hear evidence against other parties, other persons other than the spouse.
Well, that would be true at trial, too, if in
Exactly.
fact we didn't have the privilege. So
and we
that
don't
is not
have
a
the
way
privilege.
of wiggling out of the issue.
No, I'm not
evading
wiggling.
the issue.
It seems to me part of the problem is here, or it is, you can sever the trials, but you can't sever the grand jury. That's the problem.
No, because the grand jury is an investigative body.
Yeah.
You may not know who done it. You may not really know exactly what the crime is. You may not know the scope and extent of the crime.
I mean, or
maybe a broad-ranging
your example
conspiracy.
is if you involve joint venturers, conspirators, accessories after the fact, the grand jury is investigating the underlying criminal incident, and you don't split them up and say, well, you grand jury, you investigate the incident as it relates to this possible suspect, and have another grand jury, you investigate the incident as it involves this different suspect.
Right.
We just don't do that. I don't think we have a mechanism for two grand juries to be doing the same crime, do we?
And it would be hugely inefficient and hugely costly, especially in a broad, vast, far-ranging conspiracy. Maybe you have 5 different people, all of whom are married to 5 other people, all of whom could testify in some way. You can testify against these 4, but not the 5th. You can testify against those 4.
Could I just go back to Justice Glaney's question? So she testifies at the trial, at the grand jury, and some of the testimony, forget exculpatory for the minute, but some of it is simply her observations of potential, what turned out to be co-conspirators or joint venturers. Can that testimony be introduced at trial?
Of the husband?
Yes.
No. And
Not
that's-
even if it concerns other people.
Not at the trial of the husband. That's the Millett case. And that takes us right back to the text of the statutory privilege. And the text of the privilege, which we've sort of ignored at this point because we've asked other interesting questions, the text of the statute says neither husband nor wife shall be compelled to testify in the trial of an indictment, complaint, or other criminal proceeding against the other. The answer to your question is against the other. In this court in Millett, which is in the brief, it's 400 mass is the volume. In Millett, the court said against the other does not mean that the testimony is adverse to the spouse. It means the proceeding itself is against the spouse. So if proceeding number one is against the spouse as the defendant, she can't testify even though it's about other co-conspirators or joint venturers. If proceeding two, though, is against a joint venturer or co-conspirator, she can testify even if her testimony would implicate her spouse in some wrongdoing.
What is so opaque about the words other criminal proceedings that they do not include grand jury proceedings?
Well, it's not in a vacuum, other criminal proceedings. Number one, it's conditioned upon against the other, which is in the Millett case. It's also conditioned upon in the trial of, which in Pasco in 391 Mass in footnote 29 in 1984, this court said, without answering the question, maybe in the trial of means the spousal privilege does not apply in the grand jury because it is a condition of the privilege. A condition of the privilege is that there be a trial. And if there's one thing a grand jury is not, as this court and the U.S. Supreme Court has said many times, a grand jury is not a trial of anyone. It is an investigatory proceeding which decides whether or not criminal charges are warranted.
But don't you think that the wording, no matter how you look at it, is odd and awkward? I mean, you say, well, there used to be information. But was an information a criminal proceeding, or was it similar to an indictment or a complaint? I didn't think an information was a criminal proceeding.
It was a criminal proceeding. It was one way in which you could lodge a criminal charge and go to trial on a criminal charge.
Well, would you call a complaint a criminal proceeding?
I would call it
an indictment is a criminal proceeding?
Well, it's certainly the trial of a criminal proceeding, the trial of a complaint. The legislature chose to use this language in the trial of an indictment.
The trial of a criminal proceeding.
Yes, brought by an information. And the information at that time, as I cited in my brief, there's the Jones v. Robbins case, which, as we all know, said you can't go to state prison unless you've had the grand jury indict you. But in the context of that discussion, they talked about informations for public misdemeanors and informations being an appropriate charging mechanism.
So you would have us, in effect, interpret our other criminal proceeding in that paragraph to mean probable cause hearings?
No.
No.
Not prior to the issuance of the criminal complaint, no.
No, what has us interpreting that as some other proceeding no longer existing in time, such as the information proceeding.
I'm not sure if it's no longer existing in time. I don't know of any case or any statute that precludes the prosecutor from bringing in information.
It's simply parallel to complaint, indictment,
or whatever other mechanism is
whatever
devised or used to launch a...
Right. The example I like to say is, what if the legislature came along and said, you can issue a Jabberwocky and then put someone in prison?
By that definition, which admittedly, is possible under the statute, you've included probable cause hearings, motions to suppress, and depositions are all outside of the privilege.
No, you said they're in the privilege.
No, I think I was conceding that a probable cause hearing post-complaint to decide whether there's competent evidence to go to trial, the suppression hearing, which would normally just be part of the trial, and the deposition, which is to create competent evidence, preserve competent evidence for the trial as part of the trial. You're essentially taking the trial evidence then and presenting it to the jury later.
So are you saying
those are probably all within?
Let's leave criminal proceeding aside. Let's assume that means something like an information. You're reading the word trial to mean, in essence, any proceeding after the defendant is formally charged.
No.
Okay. What proceeding after the defendant is formally charged is there that the spousal privilege would not apply, in your view, under the statute as you interpret it?
Well, there's two. One, all civil proceedings, which may
We're
in
only
fact,
talking about criminal proceedings. I understand that.
fine, which may involve the spouse testifying to all sorts of horrific crimes by the other spouse.
Correct.
Even though he's already charged.
We understand.
And then you cannot introduce
correct. Well, right. Absent some other circumstances.
well
And the
case.
grand jury, because the grand jury is preliminary to the criminal proceeding. So even though he's charged in district court with a crime over which the district court has no jurisdiction, which is for the purpose of bringing the complaint, having bail set, making sure he doesn't flee the jurisdiction, taking those steps. He has not been charged in a court of final jurisdiction here. There is a grand jury. It doesn't apply in the grand jury.
All right, so there's a bail hearing in the district court, and the Commonwealth calls his wife to testify at the bail hearing. That's okay.
It may be okay.
All right. Well, I mean, you can see why this is problematic.
Sure.
Because at the end of the day, you are, in essence, undermining the whole purpose of the privilege.
That's not correct. At the end of the day, you can have one crystal clear rule which says, because the legislature did not use the words grand jury, this privilege does not apply in the grand jury. And you can compare that to the fourth paragraph, where the legislature did use the words grand jury.
Right. What would you say that the words other criminal proceeding means in that paragraph?
I would say that the legislature recognized when they adopted the privilege in 1870, with essentially the exact same language in the second paragraph and the third paragraph, that there were informations, that there were criminal forfeiture proceedings, which are discussed in our brief, that these were criminal proceedings to which the privilege would apply. And in the criminal forfeiture context, which could be brought by information or some other process, the defendant would have had to have intervened and made himself a party, which is discussed in our brief and cited in our brief, and then the privilege would apply because he would then become a party.
So it's essentially a vestigial remain that has...
No.
Well,
it's clearly intentional because...
No, but it would apply to informations and criminal forfeiture proceedings.
And it would apply to any other mechanism. The legislature then said, you know what, tomorrow, whoever gets elected tomorrow, when I'm out of office and at home in Pittsfield, could decide to come along and create a new charging mechanism, a new charging document. And I want to make sure that this privilege applies when tomorrow's legislature comes along and creates that new mechanism, whatever they might call it, unless they explicitly go back and undo this statute, which says in the trial of a criminal proceeding.
Mr. Zanini, whatever the other criminal proceeding may or may not mean, and whatever we do about motions to suppress and so on, it seems to me if you read the second paragraph and the fourth paragraph, the legislature understood at least one thing, that whatever the outer limits of court in a trial were, it did not include a grand jury for all of the reasons of all of our existing jurisprudence. It's an investigative tool, and that's all we have to decide in this case.
That is correct. Absolutely.
That's all we have to decide. And we don't have to decide what would happen if there was some circumstance after or before the issuance of a complaint in the district court. I don't know what that circumstance is.
Not today.
It's simply grand jury is all that's in this case. Am I correct?
Correct.
Okay.
May I ask another question before you sit down? On the part third, well, let me just ask it this way, first of all. Does the target of a grand jury investigation have the right to appear before the grand jury?
Only if you read paragraph third.
To include grand jury?
Right.
Other than that, is there any other statutory or case law right?
No.
Okay.
And if the legislature created in 1870 the defendant, if they granted the defendant the right to appear in front of the grand jury in 1870, no one has ever exercised that right. And I would suggest it's because we all understand that the grand jury is not in paragraph third or paragraph second.
Well, clearly Smith said that the grand jury is not, Commonwealth versus Smith said the grand jury is not part of what that preceding language was, which is similar to this.
Correct. And in 1896, Smith has decided in 1895 about paragraph third. In 1896, there's a commission appointed to codify all of the laws. In 1902, the new codification comes out as the revised laws of 1902. They do change some of the wording, but the meaning and the essence of it is exactly the same. They put the word criminal in front of proceeding, but they take out person charged with complaint and put in defendant. So Smith, I would suggest, is very much the controlling case.
Thank you, Mr. Zanini. Mr. Kersey?
Good morning. Lawrence Cody for the witness, Pili. May it please the court. First, a word about impounding. There was mentioned by the prosecution that these proceedings or some of the contents of the proceedings has been impounded. That colors the entire discussion, but I don't want the court to lose sight of the fact that while some of the content of testimony in front of the grand jury has been impounded, there's no secret that we're dealing with a case concerning a particular defendant who's been charged with a particular crime at the Dorchester Division of the District Court. So the discussion about, life before a formal charge, I would suggest is a fiction. There's absolutely no doubt, I don't think the Commonwealth can credibly contend that we're not in the middle of
So
a
what you're saying is a complaint
proceeding.
has issued against him, and now it's gone to the grand jury?
Absolutely.
So even by his definition of how this should proceed, we could view this as a sort of an extension of the complaint process, and the trial has already begun.
Well,
I don't think that would be Mr. Zanini's position.
I wouldn't suggest the trial has begun.
No, the trial proceeding.
I would suggest that the criminal proceeding, under the relevant exception in the
Correct.
statute, has begun. Absolutely.
Correct, but it is also true. It has begun in a way that is doomed to failure unless the Commonwealth can ultimately get an indictment. He cannot be tried for the crime which he's been charged in the district court.
Well, they could have the probable cause exercise in the district court.
But they're not doing that.
I don't think they are. I think they're
Maybe I'm
sticking with their effort
Can
to
your
indict.
client be tried for murder in the district court? My understanding was
No,
no.
no,
Okay.
absolutely not.
So it's been started in the district court as a means of
To get-
holding him,
And
And
to determine bail.
and it cannot go to trial. It
That's
cannot even begin the trial process, anything resembling the trial process, unless and until there is an indictment, correct?
That is absolutely true.
Okay, so it seems to me it's a little bit of a fiction to say that there are proceedings against him that could lead to trial, because there aren't yet. That's totally dependent on what the grand jury does.
That is true.
Okay. Could I ask you, if the privilege were to have the meaning you would like it to have, the interpretation you urge on us, it seems to me a lot of the wording in this statute would be surplusage. It would be much simpler to say that neither husband nor wife shall be compelled to testify in any criminal proceeding against the other. You wouldn't have to specify
would be
indictment,
simple.
complaint. You wouldn't have to specify trial. You would just go, if you want it to apply to all forms of criminal proceedings, including within a grand jury can certainly be viewed potentially as a criminal proceeding. Excuse me, they just go, they wouldn't be compelled to testify in any criminal proceeding against the other. But they don't. They use this language. They can't be compelled to testify in a trial, so it's got to have something to do with trial. And it's trial of an indictment, complaint, or other criminal proceeding. So it's got to be a trial. How is those words not surplusage under your desired interpretation?
Well, because there is more to a criminal proceeding than a trial. As Your Honor has mentioned, a motion to suppress, a bail hearing, a dangerousness hearing. I would suggest a probable cause hearing where the exercise is identical, trying to determine probable cause. The Commonwealth's arguing that it's just engaged in an investigation to find out whether, in fact, a crime has happened. And I suggest it can't argue that under the current state of affairs, which has a defendant charged below.
No, I think that what the Commonwealth, when it says it's an investigation, it's not an investigation as to whether or not a crime has occurred, but given that some acts have occurred, by whom and at what level?
And again, I think that can be a grand jury's purpose. I don't think it's this grand jury's purpose, because we already have the gentleman as a defendant charged with the crime,
Right, but
and the indictment is not an essential part of the proceeding.
How could we, I mean, one of the things that's troublesome, though, excuse me, about that position, is it would make the privilege depend upon very specific facts, circumstances, and timing in front of a grand jury presentation. Indeed, I don't, what do you think you do if the grand jury is investigating a bunch of potential joint venturers, only one of whom is married to the witness.
Well, Your Honor, the fact specificity is a problem with all the privileges. I mean, the timing of the marriage and the testimony. The problem that the Commonwealth brings up with respect to issues of trying more than one individual, those issues aren't escaped by the specific use of the term grand jury in the fourth exception with respect to minor children. All those issues are still there. A minor child doesn't, an unemancipated minor child doesn't have to testify against a live-in mom or dad.
What you're suggesting is that there might be certain grand jury proceedings where a spouse could be compelled to testify depending upon the circumstances. Suppose you do have a grand jury investigating a crime from the get-go. There is not yet, in fact, a target or a prime target, but a bunch of different potential suspects. Is that a grand jury proceeding that is, quote, against the spouse? You know, in fact, it may be that that witness who's being summoned because the prosecution thinks she would have heard some conversation amongst people that don't involve her husband. May be unaware that her husband is involved, just thinks she's a normal eyewitness to something important. But she happens to know that she also knows something about her husband being in on it. I mean, how do we sort these things out in the grand jury context to figure out which grand juries she can be compelled to testify in front of and which ones she can't be?
Well, it creates, hypothetically, it creates some of these concerns, Your Honor.
I think it creates a lot of them.
On these facts, thankfully, no such concern. There's never been a suggestion that this gentleman is anything other than the target of the grand jury, again, as evidenced by the fact that he's already been charged.
But in order to look at it the way you would like to, we would have to look at what evidence has already been presented to this grand jury, what, you know, and all these other things. Witnesses don't normally get to do that, and quite the contrary. Witnesses have no right whatsoever to know how much the grand jury has yet heard.
Your Honor, again, I would think these same problems present themselves with respect to the fourth exception. So mentioning a grand jury doesn't
No, it doesn't
cure
at
the
all,
problem.
because the fourth exception makes it clear that the privilege applies in grand jury, period.
Yes,
Against said parent.
correct, Your Honor. So if a 9-year-old girl is called before a grand jury, and there's no clear indication, as there might not be, as to whether her mom or dad might be the subject of the grand jury,
Or some relative, or, yeah.
all Your Honor's concerns are present there. How do we know that that unemancipated minor does or doesn't have the privilege? It's the same analysis.
Mr. Cody, let me ask you this. I read the single justice's decision, and he relies for the reasons stated in your opposition. So I look to your opposition, and I understand the argument about other criminal proceedings. I was perplexed, however, by the argument on Section 4 for this reason. It has long been established, this is not a new jurisprudential gloss, that grand juries are not trials, in the sense that grand juries are doing something other. I mean, there may be mushy areas about who they identify. And it seemed to me that when sometime later, quite a lot, almost 100 years later, the legislature decided to create a child's privilege, they wanted to make absolutely sure that the child could testify in the grand jury. So again, I'm looking at this case, and I think the fact that that Section 4, if there was any ambiguity in Section 2, the legislature could have, paid attention to that. And I think that from my point of view, the legislature said grand jury privilege doesn't apply. Grand jury privilege does apply for children. I mean, spousal doesn't apply. Children does apply. And from my point of view, that's the end of this case.
Your Honor, if I may, that assumes that the legislature when drafting the fourth exception in 1986, number one, even treated the prior exception.
It certainly did treat the prior exception, and I know that because it took a language out of the prior. In other words, what Section 233, Chapter 233, Section 20 did not have was a privilege for children. So the legislature says, okay, now I want to create it. And what they did is look to see what was the privilege for spouses, and they essentially tracked it. It's a little awkward because you now have shall not testify before trial. It's a little odd, but we can say before, we can get over that glitch. And they essentially tracked the language, and they said, and in addition, we're going to make sure that you don't have to testify before a grand jury. I mean, that to me is the clearest indication that they were expanding not only the group of people covered, but the circumstances in which the privilege applied. I mean, somebody was drafting right out of the second paragraph.
Your Honor, if I may, it's my understanding that the fourth exception,
Right.
paragraph 4, it's called in the language, came in response to a particular case, and I would respectfully disagree with Your Honor that represents a complete rewrite of the entire statute.
But
It's not a rewrite of the statute. It's not a rewrite of the statute. The circumstance was a grand jury proceeding, correct?
That is correct.
If the legislature had had any doubt whatsoever that the numbered second paragraph, the one, it's not numbered, but it's called the second exception, covered grand juries, it wouldn't have added grand jury to the fourth.
And if the legislature, to follow further with the Chief Justice's argument, if the legislature's position was, as you say, then since they looked at the second exception and to take the language right out of there, they would have seen that the second section didn't say grand jury, and since their focus in fourth was clearly on grand jury because that was what our case was about, they would have put grand jury into second at that time because they clearly were focused on the issue of grand jury. That was the whole purpose of the adding the fourth section, was to protect children or provide an exception for children in grand jury proceedings not to testify against the parent in response to our case on the grand jury. So grand jury was in their mind, and the second exception was also in their mind because they took the language for the fourth exception right out of the second exception. So if they wanted to add grand jury, they didn't. They were thinking about it. We would have to assume that they were thinking about it.
I think they were thinking about the term grand jury. Again, for the last time, I'll take exception to the notion that they were looking at the term grand jury as it might apply to the other exceptions. The glaring example in that regard would be they somehow didn't feel the need to insert the term grand jury into, I believe it's the third exception with respect to the privilege against self-incrimination. Clearly, if they were looking at the entire statute, they might want to say, to clean things up a bit, let's use the word grand jury in the third paragraph so that...
Oh, no, because that would change everything. I mean, the defendant isn't allowed to, the defendant doesn't have a right to testify at the grand jury.
No, but a right not to. The third exception says he can't be called to testify unless he or she so elects.
And also shall be able to testify if they choose. And that
Right.
clearly doesn't apply to grand jury.
Right.
That
But-
doesn't
but-
apply, so that they would have to be, they wouldn't
in
want to
fact,
do
you
that
can't
in
call
the
them
third
to
section.
testify and require them to take the fifth in front of the grand jury.
Correct, but they still have the privilege to do that, to make that election.
But that's constitutional.
That's constitutional anyway.
Well,
And that's what we say.
Oh,
That's
you bet it's
constitutional.
constitutional.
Your Honor, it absolutely is, although that term grand jury doesn't appear in the exception and the actual wording. If the Commonwealth has gone to great lengths to discuss the actual wording of the statute, also grand jury doesn't appear in the state constitution. Finally, on that issue, I would say that the rule of construction, as I mentioned in my brief, that says that to say something in one part infers that you meant to say it somewhere else, that's a standard rule of construction. However, there's case law that says that you don't apply that rule if to do so would undermine the purpose of the statute. And I would submit that the purpose of the statute is not to make sure that grand juries get all possible evidence, but to protect individuals in some circumstances from participating in criminal prosecution.
Well, the purpose is, obviously, what the legislature has done is they balanced interests. And reading the statute, as Mr. Zanini suggests we should read it, just strikes a different balance than the balance you'd like to strike. But it doesn't mean that the statute's without purpose. I mean, it still has a purpose.
I'm suggesting that the purpose of the competency of witness statute, the exceptions, are to carve out circumstances where individuals can elect not to testify. The purpose of that statute is not to make sure that grand juries get all available information.
No, because the balance struck.
I understand that, Mr. Cody. The difficulty, as I said, the one thing that is abundantly clear in 19th century jurisprudence, almost more so than today, and I know Mr. Zanini will probably take exception to this, is that the powerful focus on the necessity of going through a grand jury. I mean, a grand jury wasn't some technical aspect of a trial proceeding that the courts had come up with. It was, you don't get to be put on trial until you've gone through a grand jury for certain kinds of offenses. And
Grand juries were even charged by members of this court. They came out and
I mean, it was a
charged
very
the grand jury.
big deal. So when they were carving out and by the way, at that time, they truly were secret. And you didn't have television cameras sitting on the outside of the court. I mean, they were really secret. The idea was you don't even charge somebody. And so that if you're worried about spousal privilege, not to say grand jury seems to me to be quite a gaping hole, leaving aside Section 4.
Governor, if I may very
Sure.
quickly.
No, it's fine.
I sincerely do not appreciate any difference between a grand jury and a probable cause hearing after the complaint's been issued at the district court level, except some housekeeping. One is ex parte in secret. The other, the defendant, is present for all the world to see with counsel. And to say that the exception would apply at the district court level, where
I don't know what they did with respect to complaints in the district court in 1890, which is when the statute was first enacted. I really don't. But I do think that they understood the difference between a grand jury proceeding and a trial. I think the evidence is the historical evidence is overwhelming.
It's not the witness's position that this is a trial. It's just the witness's position that the grand jury is, in the context of a spouse with a complaint lodged against him, that the grand jury proceeding is a criminal proceeding.
Okay.
Thank you.
you.